Do you think Saddam got a fair trial, and why?
I think he got a far fairer trial than the public perceptions. Given the context, this was a group of Iraqis who were trying to, as I say, take control of the soul of their nation. What they did was write a code, a procedural code, that fully met international standards on paper. And then the challenge that they had in the context of an ongoing insurgency was to take that procedural code, which was full of information and laws from the outside of Iraq, merged with Iraqi law, and try to blend it into the practice in the courtroom that Iraqis could expect and could follow. And that was a difficult transition. It was a far better effort and far closer to international standards than anybody on the outside realized. From the Iraqi perspective, most Iraqis said it wasn't a fair trial or it was too fair because the procedures were different than things they were accustomed to seeing. And that's one of the reasons we wrote the book, was to document exactly what happened. We really believe in the final analysis that the historical appraisal of the trial of Saddam will be far more lenient than the current popular perceptions at the time. It will go down in history as being a fair trial, given all the circumstantial evidence and the circumstances of the ongoing insurgency. When you know the facts of what happened, he had every right to defend himself and every opportunity to do so.
And how do you think the tribunal did, as being someone who has helped to train the judges?
Well, the judges in the Iraqi process had to do what every other domestic judge would do, which is that they don't apply international law, crimes against humanity and war crimes and genocide law, in their normal practice. So they had to do two things. They had to learn all that body of law, and in their context it was particularly more difficult by the fact that Saddam had actively prevented them from learning any law, any exposure to the outside world. Which makes sense, of course. The tyrant who's committing crimes against humanity doesn't want his judges learning crimes against humanity law. But once they had learned that law, then they had to merge it into an Iraqi procedural practice that they could apply it. And that's the difficulty. So you see lots of language in the opinions that you have to read very closely, and if you're an expert, you understand exactly what they're saying. But they're not saying it exactly in the same way, using the exact vocabulary that somebody in The Hague might, but the essence is there. And that's what they really, truly should be praised for doing, was that really genuine, authentic, good faith attempt all the way through to merge those bodies of law. And what's interesting about that is that every country around the world that ratifies the International Criminal Court statute in their domestic practice is having to do exactly the same thing. You've got domestic judges grappling with this body of international law, applying it in a domestic setting, exactly in the same way that the Iraqis did. And that's why the book is a very useful read for many people, because there's a lot of best practices. You can learn from what they did right, and you can learn from what they might have done better, so that when you're faced with the exact same set of issues and the exact same challenges in your domestic system, you can do it better.
So what do you think the tribunal should have done differently now, writing this book and looking back at the trial?
Well, not just looking back. I mean, and we were legal advisors at the time urging, one of the great myths about this trial is the degree that Westerners, Americans and Brits and other people control the processes. This is an Iraqi trial from start to finish. It's Iraqi judges applying Iraqi law, and to the extent that they're applying international law, it's because they took it from the international law and merged it into Iraqi domestic law. So at the time, we would urge them to do several things differently. Sometimes they did, sometimes they didn't. A couple of things in particular. One is the practice, very common in the West, when there's a motion made, of immediately responding to that in writing. Sometimes the judges, many times, they would respond from the bench orally, and that would be ignored around the world. It would be lost. We urge them to respond in writing. The Iraqi practice is, which is what happened in this case, to respond in writing in the context of the final trial judgment, which is perfectly legally valid, but so much time has gone by, and in the meantime, the defense has said, see, the judges are ignoring our motion. We're really right on the law. And they've run around the world in the media saying that. And in the final analysis, when the judgment finally came out, the judges were right on the law all along. So we urge them to respond to those motions in writing at the time. Okay. And in other trials later, they began to do that. The other big thing is, of course, the control of the defendant. In Iraqi law, the defendant has a right to participate in the defense, has a right to question witnesses. And the judges, reverted back to the Iraqi practice. The unfortunate consequence of that, of course, was that the perception was that they allowed the defendants sometimes to take control of the courtroom. What was never shown in the media was Saddam and other defendants coming back into the courtroom and apologizing to the judges. The judges were in control of the trial from start to finish. It was really a perception that the defendants were in control of the courtroom, because every time they misbehaved, that conduct was addressed appropriately and in accordance with international standards. But it could have been managed better at the time.
So how do you think Saddam did in the trial in following the new rules and things like that?
Well, his strategy, which really then dominated and dictated the defense strategies of the other defendants, was very clear, which was to take control, to dominate the proceedings, and create this perception of illegitimacy. The funny twist was that so many times he would address the judges with respect. But I will tell you, having watched the trials from the courtroom and from the environment, Saddam was a very different defendant when the cameras were on and when the cameras were off. For him, it was very much a public performance, because he was trying. For him, it was all about reputation. It was all about image. He didn't expect to be acquitted, even though he had the full right to participate. So from his perspective, it made perfect sense to try to delegitimize, try to dominate the proceedings, which is one reason why he used them repeatedly to try to inflame the insurgency. There were over a dozen times in the trial where he specifically spoke not to the judge, not to the merits of the legal case, but to the insurgents and to those who were conducting conflict outside the courtroom. It had nothing to do with the trial, but for him it was a public performance.
So how was he different? When you talk about how he was different when the cameras were on and the cameras were off, because so few people have that perspective.
Well, for Saddam, when the cameras were on, to appear compliant, to appear orderly, to appear completely deferential to the judge, was very contrary to the public image of power and control that he wanted to portray. In fact, he apologized to the judge many, many times throughout the trial, more than a dozen times. He would follow the judge's instructions frequently. When the cameras weren't rolling, Saddam was much more engaged in the defense, much more calm, much more attentive, just listening and taking notes and things like that. Of course, when the cameras were on and he knew it, that was his chance to then be more dramatic. And really, it was all about image for Saddam. It was all about people looking up to the great father figure, which was the image he tried to cultivate. Of course, one of the amazing things that people laughed at around Iraq was Saddam, the secular murderer tyrant, walking in with a Quran under his arm. And they just snickered. It was like, because it was a thoroughly secular regime from start to finish.
So how did the witnesses react to him when he was the one, asking them questions? One
of the amazing things about this trial, and truly revolutionary for this region. Remember, this is a region that had not had the case law available in Arabic. So the great war crimes trials of our era, the Nuremberg cases, the Eichmann trial, the jurisprudence from The Hague, the ICTY and the ICTY, none of that was available in Arabic. It's now available for the very first time. And one of the incredible historical aspects of this trial is that Iraqis and other Arabs around the region can now read these opinions in Arabic and understand this body of law for the first time ever. So what was amazing about this trial was watching witnesses who would come in who, when Saddam was in power, standing up to Saddam and the regime meant instant death. To watch those people come in, sit down 10 feet away, 12 feet away, look him in the eye and say, "This is what you did to me. This is what you did to my family. This is how you destroyed my life." Mm-hmm. Was very powerful. And it was gripping TV in Iraq. People watched every minute. One of the witnesses, for example, was 14 at the time his village was destroyed. He grew up in a concentration camp out in the desert. He had come in as a young man now to testify about what happened. It was gripping. It was powerful. And of course, given Saddam's image, it was precisely in those most gripping, powerful, emotional moments of the trial that he would tend to be the most disruptive. He didn't want people paying attention to the actual stories of those Iraqis. And as we say in the book, every Iraqi who testified literally spoke on behalf of thousands of other similarly situated victims. There were thousands of Iraqis who could have come and told exactly the same kind of stories because they all suffered under his regime. It was just that these complainants, as they're called in Iraqi law, had the opportunity to come and face Saddam.
So when you were sitting there at the trial, what was the time when you were most moved, or what part of the trial did you think was the most powerful?
Well, the most incredibly powerful things were the images of victims testifying face-to-face, nose-to-nose with the tyrant. It was incredibly powerful that the law itself served as the equalizer to allow ordinary Iraqis who had no voice, who would have been killed by the regime for simply voicing complaints, to watch them come in and, aided by the power of the law, the power of the judge, to watch them able to stand up to the regime. That was powerful. The second most powerful moment, which we document in the book, and I was actually there for this day of trial, was during closing arguments. The defense counsel came in. The retained counsel paid by Saddam had boycotted against the warnings of the judge, so the judge appointed standby counsel. The Tribunal Defense Office counsel were there to deliver closing arguments, while Saddam's lawyers sat in a hotel room in Jordan, watching on TV. Saddam stood up, and he went from about 8-10 feet away. He wags his crooked finger, and he says, "If you speak, you are the enemy of the state." Of course, that's where the title of our book came from, Enemy of the State. Now, on nationwide live TV, that's essentially a death threat. Saddam is saying to all of his followers, to anybody out there who sympathizes with him, look at this man's face, notice who he is, find him, kill his family, persecute him. That defense lawyer looked back at him, and even in the face of that threat, cleared his throat, took a drink of water, and began a closing argument. It was powerful. And it was a graphic, tangible demonstration of the rule of law in practice. This was a defense attorney standing up, appointed by the court, to defend the tyrant in accordance with legal process. And I must say, having listened to them, the defense closing arguments went on in Saddam's case about 4 hours, delivered by multiple defense attorneys. They took turns. They spelled each other. And they were good closing arguments. They weren't perfect, but they were very strong closing arguments.
Don't you think it's fair to say that any of those lawyers and the witnesses were putting their lives at risk by testifying?
Oh, of course they were. Which is one reason why the lawyers were given the choice to have their faces on television or not. Both the defense attorneys and the prosecutors and all of the participants in the trial. Some did, some didn't. And you know, the fact is, one of the great tragedies of this trial is that 3 members of the defense team were killed during trial. But the deputy prosecutor's brother was also killed during the trial. Witnesses who testified on live television went back to their villages and were persecuted. Some were killed in their villages, which is why this trial is such a gripping saga. Here are people literally putting their lives on the line, as well as risking the lives of their families, the lives of their children, to do what's right, to stand up for the rule of law. And if you ask them, in fact, there's a quote in the book from one of the judges. He was asked, "Why do you do this?" And his answer, he said, "This is a battle, mister. And if I don't show up and you don't show up, then we can't win." And that's the kind of spirit that we wanted to document. They were courageous. And they didn't do everything perfectly, but you have to respect the integrity and the commitment that they showed to a real Iraq built on the rule of law.
So at what time did you say a book needs to be written about this trial?
Well, we said it many times, but saying it and doing it are two different things. I think the moment of closing argument, when Saddam stood up and he wagged his finger at that defense attorney and he said, "If you speak, you are the enemy of the state," which on live national television was essentially a death threat. And when I watched that lawyer clear his throat, take a drink of water, staggered by the import of what he was about to do, but then begin to speak and begin an eloquent 4-hour closing argument, it was powerful. And I said, if we don't document what these people are truly doing, then it'll be lost for history. And the region, people need to understand what really happened, not the media images, not the short-term 12-hour media cycle of the story. People need to understand, for the sake of history, what truly happened every day in this trial. The defense team, by the way, who made those closing arguments, were later nominated for the very distinguished Rule of Law Award in Great Britain. Now, they didn't win, but the fact is that what they did was incredibly courageous.
So when you were sitting down to write the book, do you feel that you wrote it more as here are the facts of what happened, or, what did you think about and the way you wanted this book to come out?
The major theme we worked on was writing an account, a narrative, that puts people in the flow of events. So there's lots of law, that you learn a lot of law in reading the book. But the law was implemented by people. It's a story about people. It's a story about events. So, for example, the chapter on the capture of Saddam. It's the sights and the sounds and the smells, and you feel like you're there. Repeatedly during the trial, the description of days in court, you feel like you're there, because that's what we wanted, was people to understand the real dynamic of what happened. And then, of course, the chapter on the execution. You're in the room, you can smell it, and we describe it in that much detail. But the other big thing was that there's so many factors that weren't shown on television, that couldn't have been shown on television. So we wanted to put all that into context so that people really could understand not just what they saw in those little snippets on CNN, but what was really happening, in fact, at the time.
Now, you were actually in the courtroom for some of the days of the trial. Explain to a Western audience, how different did it feel being in that courtroom as opposed to people who may have been in a Western courtroom?
Right. Well, it's one of the great myths of, really, in all the public consciousness, that Westerners controlled the trial. During the actual trial itself, there were no Westerners in the courtroom. It's an Iraqi trial with Iraqi judges governed by Iraqi law. All of our work was outside the courtroom to teach, to train, as I say in the book, to cajole, to try to educate them. But once trial began, we were relegated to the back room, watching on closed-circuit TV. There were many, many occasions when we would be in the judicial chambers. We would talk to the judges about their rulings, about the law, about what we advised that they should do in response to a particular issue. They would put on their robes, they would walk up the 3 stairs, be on the bench, and by the time I could get around to where we could watch on television, something would have happened completely unforeseen under the control of the Iraqi judge. It was an Iraqi process, which is what's important, the fact that the Iraqis themselves demanded control of this process from day one. And I think what they did has to be recognized as courageous. Now, they didn't do it perfectly, and we document some of the mistakes that they made in the book, but the very spirit with which they did it, to try to, as I say, reclaim the soul of their nation, to try to take the rule of law and demonstrate it in practice to a nation that was just beginning to work out the kinks of democracy and just beginning to have a free and fair dialogue, was incredibly courageous.
Yeah, the law is confusing here, and we've been doing it for how long? Well, is there a person that you feel you were really affected or inspired by, or who moved you during this whole process?
Oh, I couldn't single out one person. There were so many. Of course, we profile Judge Rajuhi, who was the youngest of the judges. He was the chief investigative judge, very courageous. He was the first Iraqi, the back of whose head became famous around the world on July the 1st, 2004, when Saddam made his very first televised appearance before the Iraqi judge. That's Judge Rajuhi, and we profile him. So many others, though, that really, truly were both courageous, but were also servants of the law. And some others, of course, who are not named in the book. That's one of the key things that we had to do, is to be very conscious of security. Some of the judges and some of the prosecutors and some of the defense counsel who inspired us the most can't be named in the book for obvious reasons. One in particular that I'm thinking of, who this would not have happened without him. He literally poured his whole heart, his whole being into the process, into writing the opinions, into crafting it, into arguing with his colleagues to try to get the right resolution. he can't be named for security reasons.
So how did they react? I mean, when you were kind of teaching them and counseling them on these different areas of the law that they hadn't dealt with in the past?
Well, they were very eager to learn from the very beginning. They were very eager to learn, and I would say, with a few exceptions, but you find that even in our classes, they were very diligent students. They would study, they would come in having prepared, they would have notes and lines and highlights and lots of questions. Many of my teaching opportunities with them sort of became, I would almost say degenerated, but became question and answer sessions. I would simply come in and say a little bit of what I wanted to teach, but then respond to their questions, and I would use the opportunities of their questions to then get in the subject matter of other things that I felt they absolutely needed to have. They were very diligent in the study and the application of this. And of course, remember, this is all international law coming from outside Iraq, developed around the world, accepted. And what they're struggling to do in their system under their domestic procedural code is to apply international law properly and appropriately, which is one of the other incredibly remarkable aspects of this trial. For the first time in Iraqi legal history, you have an almost 300-page opinion which spells out every nuance of the legal reasoning, of the facts, of the evidence, and then that, of course, was followed up in the second trial in the Anfal genocide case by an almost 900-page opinion. Again, that's unprecedented in Iraqi legal practice.
Isn't it hard, too, the fact that they were being urged to accept kind of foreign laws and outside laws, or were they all open to accepting these new procedures?
Well, the Iraqis knew that their domestic system, like domestic systems all around the world, did not have the substance of crimes against humanity, some of the war crimes, and certainly genocide law. They're not alone in that. And in fact, every country that ratifies the International Criminal Court statute and joins the ICC has to go through exactly the same process, taking that body of law and merging it into their domestic system. That's why what they did was trend-setting, and they're the first country in the region to do that completely, which is very important. And they're very proud of that.
How do you think they're doing now?
Well, of course, this was the first trial. And in the beginning, one of the things that's not public knowledge, Saddam was never intended originally to be one of the defendants in the first trial. The Dajjal case was selected because it was a discrete timeline, it was a discrete set of events, and factually, it was the first case ready for trial. So that it moved towards trial. The difficulty is that under Iraqi law, prosecutors have almost no discretion. When the investigative judge discovered evidence specifically linking Saddam himself to that discrete set of crimes, Iraqi law required him to be charged. So one of the first appeals was to add him to that case that had already begun. Of course, the Iraqis themselves learned a great many lessons from the conduct of that trial, and so now, in subsequent trials, they've applied many of those same things. They've not been as fiery and as publicly contentious as this first trial was.
How do you think having this trial put on television for all Iraqis to see, how do you think that affected the trial? And do you think the trial maybe would have been better if it was or was not on television?
That's one of the most fascinating questions, and you could argue about it all day long. One of the Iraqis, well, for starters, I think you need to understand that the decision to put it on television was incredibly courageous. Remember, our own federal courts are not on television. Many state courts are not on television. In the United States even, you don't see televised trials. So that was an incredibly courageous decision. And the reason they did it, even though we can second-guess the wisdom of that, but the reason they did it was to demonstrate the rule of law in practice. They wanted people to see the process of justice. They wanted to see Saddam humbled at the feet of the judges in, metaphorically, subordination to the power of the law. Of course, he used that televised vehicle, as the vehicle for imagery and for drama. I asked that exact same question to an Iraqi, an engineer from Basra. I asked him, I said, was it a mistake to televise the trial? And he said, I believe it was a mistake. because it shows people that this is a different process than what they would get in an ordinary Iraqi courtroom. But then he said, I believe it would be an even bigger mistake, now that we know that Saddam is using this as a platform for drama and theatrics. He said, I believe it would be an even bigger mistake to stop televising. So that they understood that this was a tangible demonstration of the rule of law. And remember, in Iraq, this was primetime TV. This was gripping. People watched day after day after day, and if they didn't watch on television, they listened on the radio.
Well, I can understand why. So do you think that Iraq is better off without Saddam Hussein?
Well, certainly. Without Saddam and without the regime, they're better off. The stories, when you go to Iraq, one of the incredibly moving things is to talk to people about what they suffered under the regime. This was an Iraq where Saddam's will and Saddam's image was completely dominant. So there's no question Iraq is better off. The real question is, were they better off having tried him? Because many Iraqis, most Iraqis, when you talk to at the time, they said he doesn't deserve a trial. He needs to be shot on sight because of what he did to my family, or because my husband's in this mass grave, or because he destroyed over 2,000 Iraqi Kurdish villages, bulldozed, literally buried under the ground, over 2,000 Iraqi villages. And in that standpoint, I still would argue that they did the right thing, to put him on trial, to develop a legal system, to demonstrate, no matter how painful it was, that they did the right thing, rather than just summarily executing Saddam or any of the other leading Baathists. Remember that the tribunal was not set up solely for Saddam Hussein. It was set up, as the statute says, for the leading Baathists who were responsible for the crimes. So you've not just seen Saddam prosecuted, you've seen his vice president, you've seen the chief judge of the Iraqi Revolutionary Court in the jail trial sitting next to Saddam. You've seen now Tariq Aziz, former foreign minister. You've seen the former defense minister on trial. You've seen Chemical Ali, who was responsible for the Anfal genocide in northern Iraq against the Kurds. All of those people have faced trial, not just Saddam.
Talk to me about who this book is dedicated to.
Well, the dedication was difficult for us. It brings up so many memories in each of us, my co-author and I. The dedication reads as follows. It says, to Riyadh and John and all those who have sacrificed at the altar of human freedom and dignity. Riyadh, of course, for those who don't know, was a very inspirational figure in the American embassy. He was an Iraqi translator who was really the dean of the translators in the embassy. He was older, he was wise, he was very professional. He was murdered a week after he warned me on my second trip to Iraq. He said, Newton, he had a very stentorian British accent and a deep voice. He said, Newton, it is very dangerous, be very careful. And within a week he had been murdered on his doorstep. John was a young officer who I met at West Point when he was one of my students. He married into my family. He was killed in August of 2007. Those two individuals were incredibly powerful in their own right, but they symbolize thousands of others who have sacrificed for the sake of principle to do the right thing, to bring the rule of law in place of the tyrant's law. And we wanted to recognize not just them individually, but the spirit of the people, both Iraqi and American and Brit, and all the other members of the coalition that have been there, that have sacrificed. That's what we wanted to recognize. So that's why it says, to Riyadh and to John, and to all those who have sacrificed at the altar of human freedom and dignity.